Hello, good afternoon, participants who joined us today. Let's wait a couple more minutes. We still have friends coming in, and we'll start really soon. Hi guys, if you know your friends are still coming in, please let them know. We will start in a couple of minutes. Hi, good afternoon, everyone who's joining us here. My name is Richard, and I'm the Assistant Secretary of the Alumni Association Committee in year 2021-2022. Thank you for joining us here today. So the Alumni Association Committee, we are organizing our monthly talks in different topics. So last month we had our GI topics, IBS versus IBD, and this month we proudly to invite Ms. Tiffany to join us to talk about medical negligence and duty of care. So let me introduce Ms. Tiffany more. So Ms. Tiffany, she graduated in London School of Economics with a law degree, and she came back here and started with iHealth Healthcare Group, and she's the head of strategy and governance. She's also a speaker in multiple topics regarding medical negligence in multiple occasions, including medical and dental advisory committees and university. So she's a founder of a LOCUM apps, and we are very proud to have her here today to share about medical negligence and duty of care. So now let's invite Ms. Tiffany to start the talk. Thank you.
Thank you, Richard, for your warm welcome. Okay, let's just start off to make sure that everyone's here with me. If you all can hear me, can you click on your reaction button and give a thumbs up? just so I can make sure that we're all able to hear. Okay, I see lots of thumbs up. Okay, great. So as Richard already mentioned, what we are doing today is we're going to talk about medical negligence and duty of care. And I'm currently the co-founder of LOCUM Apps, which is an app that connects doctors and other healthcare staff to healthcare facilities. So I will start with an introduction of what our app does first. As introduced by Richard earlier, I'm Tiffany. I graduated with a law degree from London School of Economics. My sister also went to IMU. Some of you may recognize her because I look just like her. She's also a doctor in IMU. And I was previously a Bank Negara lawyer. So I used to work in regulatory law, which means that my understanding of law is one that's very restricted. And hopefully what advice I give you today about medical negligence will be something that you can take with you in your practice. And hopefully it means that you never ever have to deal with a case of medical negligence. I am New York qualified, but I'm also working towards qualifying in London as well as in Malaysia. So in brief, LOCUM Apps is a mobile application that connects healthcare facilities to healthcare staff. So what we aim to do is be sort of like the e-hailing of healthcare. And my understanding is that quite a number of you are still housemen, which means that you do not do locum jobs. But in the traditional locum landscape, when I worked in a hospital, when we tried to find locum doctors, sometimes the process is very old school. We would text our doctor, ask them to call their friends. I'm sure you may have heard of situations where your colleagues will ask you, hey, can you cover me tonight? Can you cover my staff? Do you know anyone who's available? And this sort of process can be very, very unsafe for the doctors as well, because what you are doing is that you are sending your qualification details, you're sending your IC, you're sending information to people over WhatsApp, which we think is not the most secure thing to do. We have also heard cases where people who try to do locum jobs end up having their identity stolen for loans, for different things, because you have your IC details, your qualification details, and you tend to share information with people if you believe they'll give you a job. Hopefully with LOCUM Apps, this situation can be resolved, and I will show you how in our next video. Our app aims to do that. So let's just play it.
Here's the situation. It's a busy morning in the hospital and there aren't enough healthcare staff to cover the shift. Managers must resort to interviewing dozens with troublesome last-minute phone calls, emails, and online forums. The shift is finally covered, but what if the staff arrives late? Or worse, doesn't show up? This is how LOCUM Apps can help. On the same busy morning, healthcare facilities can log on to LOCUM Apps and fill in the details for the vacancy in just 30 seconds. The app will immediately pair healthcare facilities with available qualified locum staff, and just like that, a job is booked. For the staff, they get to maximize their available time whenever, wherever, just at their fingertips. Our features are comprehensive but simple. Get access to our entire database of healthcare professionals, clinics and hospitals, all verified by the LOCUM Apps team. Get notifications for locum jobs on the go so that you don't have to check for jobs consistently. Fuss-free payment for healthcare facilities by just clicking Confirm. Select jobs or locum staff that's nearest to you for maximum convenience. Track your jobs on a timesheet to review your jobs and know how much you have worked in that month or year. Get monthly financial reports to track how much you have earned in a month. Wherever you are, you can book shifts at the tap of a button. It's as simple as that. Download LOCUM Apps now on App Store and Google Play. Start booking locum jobs faster, easier, and safer today.
Jom LOCUM! So that is the introduction to LOCUM Apps. And for us, what we have found, or what I'm very proud of, is the fact that some of our top earning doctors have earned over 11,000 just doing part-time work within 2 months. So this is something we feel is a great opportunity, not just for doctors, but also for dentists, pharmacists. We also have confinement nurses. My understanding is that for those who are still doing their housemanship, you may not have your APC yet, which means that you may not be qualified to do locum jobs. However, if you're interested to do home calls, or we have something called caregivers, those are opportunities that you can explore as well. And we also have a category for that. So caregivers are considered less formal less formal healthcare staff. These are those who perhaps have some background about how to address wounds and you would like to do short procedures at someone's home. Those are also opportunities. So all you need to do is download our LOCUM apps. All right, so let's just give a general overview of how our community has grown. This app has only been born or was only launched less than a year ago. Our first day of operations was the 5th of May last year. And since then, we have over 3,000 registered staff. This is something that we are quite proud of because we've also managed to make it sort of a community. What we did before the pandemic really went crazy was that we used to host LOCUM apps events, and this would be events where people, doctors such as yourself, nurses, pharmacists, you would all gather together. We will find restaurants who want to promote this healthy eating lifestyle, and our doctors or our LOCUM staff would become sort of like influencers, and you'll be able to go and taste food for free, give your comments and your reviews. We have a website to put those up as well. In addition to that, we plan to host training sessions. We want to be able to empower our doctors to not only be good in service, not only good in caring for health, but also maybe in other things such as financial management. So these are things that we think perhaps the medical fraternity can see more of and improve on as well. In addition to that, we also have this column called LOCUM Charity, and that's something that is still active till today. If you go to our website, www.locumapps.com, you will see this charity section where we raise funds from the public in order for us to be able to serve at places such as old folks' home or children's homes. And then we either invite doctors to become volunteers. So this can be doctors, nurses, or people who are not fully qualified as well, who want to help out in these situations. So when we went to an old folks' home, we got one of the doctors to come and give a general body checkup, blood pressure check to all of the old folks who had not seen a doctor for about 9 months. So this was very useful and the people were very, very happy. We raised funds from the public for that. We also sell merchandise in order to fund the equipment and the supplies and materials needed. So if you as a doctor, or you as any medical staff, if you are interested in also contributing to charity, you can download the app and register as a volunteer. We are also proud of the fact that we've gotten quite good feedback on the app. So some of the agencies that work with us is a care agency. What they do is that they use our app to find other caregivers and they send them to the homes. So they find it helpful and user-friendly. Our doctors themselves say that the technology is new and it's a better way to book locum jobs. One of the things that we found useful about this app is that when you book a job, you are restricted by a timer. So you are paid according to the hours that you work. In many places, although they tell you they charge per hour, sometimes doctors or nurses or any clinical staff find themselves working for longer than the time period. For instance, if they tell you a job's from 8 to 8, but because the next locum hasn't showed up, you end up working from 8 to 10 or 8 to 9. And that extra hour tends to go unpaid. However, with our app, because there's a timer system, even if you work for half an hour longer, you are also compensated for that. And this is what Mr. Lavinan here found very useful because he's a radiographer and he thought that was very good because he was asked to stay an extra time and he got paid more for that. However, on the hospital or clinic side, if you end up working less time, they are also able to adjust accordingly. So that's something that's unique to our system. So these are just some of the reviews. We have this feature called Locum of the Month. So whoever takes up jobs on our app, if you get 5 stars consistently, you are rewarded and honored as the Locum of the Month. So there's only one a month, and then we will interview you and feature you and also sometimes give you some prizes as well. So, okay, before we get to that, I think I just wanted to know, what is the understanding here so far? Does anyone have questions about locum? Do you want to hear about whether we can be a locum or should we just go on to medical negligence? Maybe if you want to hear more about whether everyone can be a locum, you can give a thumbs up. If you want to go on, you give the high five hand thing. If I can get an idea. Thumbs up for knowing more about locum, 5 fingers to move on to medical negligence. Okay, I see some thumbs up. Okay, let's talk a bit more about locum then. All right, so this is a bit legal, but I'll just give you a general summary. So in general, in order to be a locum in Malaysia, you will need to get written permission from your head of department, and you will need an MMC. Oh, sorry, you will need to apply from the MMC to update your APC. So this situation is not that closely monitored by Ministry of Health in the sense that if you are doing locum one-off or one-time job, they don't really mind. However, if you plan to do locum at the same clinic over and over again, you are advised to add on that clinic to your APC as well. In addition to that, you cannot do locum if you are in government practice on, for example, during your lunch break. I think this should be quite obvious, but you will be surprised by how many people try to get away with that. They will disappear in the afternoon, go and do a short-term locum somewhere else and come back later. That is strictly not allowed. In addition to that, foreigners are actually not allowed to do locum unless you get special permission. So this applies even to those who are medical contract officers in Malaysia. You have an APC, you may not do it if you are not local. So definitely is something to pay in mind if you have any foreign friends who are doctors in Malaysia. You will need at least 1 year of experience after having a full registration certificate. And this is what I mentioned earlier about after office hours, public holidays, weekends, annual leave, or study leave. The final point I want to mention that's quite important is that you are fully responsible for yourself while you carry out locum in private clinics. And what that means is that not only do you not really have someone monitoring you, but in case of the event of liability, or in the case someone sues you, you will need to cover your own legal fees. So the private practice does not cover you as a locum, neither will the government. So normally we advise all doctors who intend to do locum jobs, please buy personal insurance. And there are many partners that can do that for you. For example, Dr. Shield, they have quite a good locum doctor rate. But I'm not advocating any one particular insurance company, but definitely before you do locum, please ensure that you are properly protected by insurance. So that is the general idea of what it takes to be a locum in Malaysia. So in summary, you will be able to work at registered private premises. You will need permission from your department. You can do it after office hours. You need at least 1 year of experience, probably get your own insurance. You have to be local and you should list the location under APC if you plan to do it more than once. Okay, sorry about that. All right, so earlier I mentioned about the locum apps events, right? So one of the things that we do is publish us on locumpress.com. And that's also where we publish the reviews by doctors. So any of you would like to share your opinion, write in, please feel free to submit articles to us at Locum Press. You can contact me on my team. She's already posted our details on the chat box. So if you're looking for somewhere to contribute an article, we are always looking for doctors to write. So your president, Dr. Al, has also contributed to us, thankfully. And we also have had MOs write in about scalp health. We've had doctors writing just generally about their experience in the hospital. So I think if you're looking for a platform, we are always looking to take in more articles written by our doctor peers. In addition to that, our team also writes articles that are medically linked. Sometimes it will cover topics that they've done general research on. What we are looking for as well are doctors who would like to fact check this for us or maybe give us a quote. And this can improve more of the quality of the articles that we write. Because I think most of you also are aware that there are many people trying to jump on the health bandwagon without actually knowing whether it's healthy. You know, how many times has we seen food being sold or shops or restaurants selling things that would say, this is healthy, this is good for you, but as a doctor, perhaps you look at it and you know that's simply not true. So we hope to correct the misinformation in the market with our website, Locum Press. So please feel free to take a look. Also go on Facebook and like our page if this sounds interesting to you. And now we'll go on to the meat of today's talk and the reason why you chose to spend your Saturday to listen to this, and that is about medical negligence and duty of care. My objective from this talk is hopefully by the end of it, all of you would know what conditions or what behavior would keep you protected from getting a medical negligence claim. In the past, Malaysia used to not be a very litigious society. People would tend to close their eyes when it comes to doctors. They would say, it's okay, the doctors tried their best. Unfortunately, probably due to media, if we've gotten a culture or society has gotten a bit more, how do I say it, American? Maybe, I don't know, a bit more litigious where they are more willing to sue. So with that in mind, I think our doctors also need to be aware of the situations that they can find themselves in. This will apply not just to doctors, but also to anyone in the medical profession, whether you are in management, whether you are a nurse. So please pay careful attention to medical negligence. So what is medical negligence? What it means legally is that it's the breach of a legal duty to take care which results in damages. So negligence is the omission to do something which a reasonable man would do, or if you do something that a prudent and reasonable man would not do. So it could be, for example, if you have a child and you do not feed the child. Because you did not feed them, it also means that you are negligent. However, if you fed them something wrong, let's say you fed them food with nails in it, that is something a reasonable man would not do. And that action also can result in a negligence claim. So what happens if there is a negligence claim? What are the kind of damages that could occur to you as a doctor? What do you have to pay the victim? Well, in this case, the laws of and the courts of Malaysia have concluded that you might have to pay for the loss of earnings. Let's say you harm someone negligently. If they are not able to work for these 2-3 months, you might need to pay them the salary they would have earned. You might also need to pay them for the loss of the future salary. This can happen if you're dealing with children or young youths or teenagers or anyone in their mid-20s, when they have a long career ahead of them that they are no longer able to pursue due to medical negligence. This could mean that the doctor is responsible for paying for their future earnings over a long time to come. You also might need to pay them for their loss of earning capacity. So let's say they say, right now I'm a manager, but I could have been CEO. You may need to compensate them for that raise that they would have gotten had they not gotten injured by you. Loss of amenities, what this means is that if they don't have the ability to use their arms anymore, that could mean that you need to pay them for the inconvenience of having lost their arms. Pain and suffering, that's one more. Nursing care, this is straightforward. You might have to pay for their use of something like LOCUM apps, medical expenses and transport, as well as legal fees. So this is a big disadvantage. Even if you lose a case, you might have to pay for their successful lawyer's case against you. So these are the things that you want to be aware of if you lose a negligence case. But what happens if you don't lose? What happens if they just sue you and you win? So although one is innocent until proven guilty, we have found that in any situation where someone has sued a Malaysian doctor, their credibility is strongly affected, even though they did not lose the case. So this is why in today's talk, we are not just going to talk about how you can avoid being found guilty, but also how you can avoid someone suing you in the first place. So these cases are also available on public record. Even if you do win, if someone Googles your name, if a lawyer searches up your details, these are information that can be found by anyone. So you do really want to avoid any kind of negligence case. And also it can destroy the healthcare provider and patient relationship. Patients start to get mistrusting of hospitals. They start to feel that any kind of healthcare establishment is harmful and it's costly. You have to take your time off work and it can be complex. So these are some of the disadvantages, which is why you want to be a bit more careful about medical negligence. So now that I have sufficiently scared everyone, let's go into what exactly is negligence. So negligence is made up of 3 principal duties. So number 1 is the duty of care. So this is what the court will say is what you owe a patient. So all doctors and all medical staff, automatically, your patient, if they are admitted to the hospital, you have a duty of care to them. This question is a bit more unclear if, let's say, you're at a wedding and a friend turns to you and goes, hey, I have this lump. Do I have, cancer? And you say, no lah, this is nothing. So sometimes in rare circumstances, this friend of yours may sue you if they are found to later on have a condition. So you do want to be very careful about the things you say to even just your friend, even if a relative. You want to be very careful about that. Always advise them to, maybe you need to see a doctor. This is just my view. Perhaps you need screening. I cannot advise you more until I have your full medical records. So those are things you want to add to your syllabus instead of making a guess. Because once you are a doctor, the duty the law places on you is a little bit higher. The second item is the breach of duty or failure to conform to the standard of care. So when we set a duty of care, the law says that you need to behave at this tier, perhaps. But whether let's say you don't do it, you completely breached it. But let's say you did it, but you did it badly. That is failure to meet the standard. And that is also something that can be considered negligence. And finally, those behaviors, the duty and the breach needs to lead to damages. If a patient comes to you, they say, you did not take my consent, you did not advise me properly, but nothing happened to them, right? There was no harm. Very likely the court will say that there is no negligence there because nothing really happened to the patient. There was no bad outcome. So let's go into each item in detail. But are you guys still with me? I think I need to see more reactions because I know this topic can be a little bit heavy. If you're with me, yeah, thumbs up. Okay, I see a few thumbs up. The rest of you who are not thumbs upping, do you need me to slow down? No, okay, we're good. Please feel free to ask any questions in the chat group and I'll go to them later as well. All right, so let's look at the duty of care. So a duty of care is an obligation or a burden imposed by law, which requires a person to conform to a certain standard of conduct. However, the person will only owe a duty of care to those who are within his contemplation who will suffer foreseeable loss. A lot of legal words here, but basically what this means is that if you can imagine that if you fail to do something, you can cause them harm, then yes, you do owe a duty. This situation is related to how close it is to you. For example, if let's say you didn't turn off the lights let's say you turned off the lights in a clinic, and 20 hours later, someone walked in and they slipped and fell because the lights were off. Can you be held to be negligent, or can you be held to have a duty of care? The court will say, could you foresee that 20 hours later someone will walk in and this person will not turn on the lights? So these are the kind of questions that the court will ask. And as you can see from my explanation, it's not a very clear-cut situation. But the law has already said that you as a doctor, if a patient has been assigned to you, then you immediately have a duty of care for them. The second thing is that breach. How do you know whether you've breached the duty? How do you know whether or not your behavior is considered one that meets the standard of care? So after proving that the doctor or hospital owes the patient a duty of care, the patient must further prove on a balance at probabilities that the conduct fell below the required standard. So the thing about this is the patient doesn't need to show that you 100% failed to care for them. They don't even need to show that you 70% failed to care for them. They just need to show that more than 51% chance of it is that you were negligent. So these odds are, it's a half odds. If more than half of them would feel that, this doctor didn't do a good job, you could be found guilty, which is why it's very important to be very careful when it comes to this kind of thing. It doesn't even need to be clear-cut. As long as on the balance, it looks like you could have been negligent, that could hold you liable. So what the law has said is that, okay, how do we even know whether this standard is who is going to determine this 50%? Who makes that judgment? And the law has said that this should be the standard of the reasonable man. So we all know unreasonable people. Unreasonable patients could be patients that complain when you injected them that you caused them pain. They're like, no, this doctor caused me so much pain. And it could be because this patient is unreasonable. However, if a reasonable person says that, no, this hurt more than usual, the doctor yanked me and bruised, then the law could say that, that is something that a reasonable man would agree is negligence. However, when it comes to medical care, you guys have specific knowledge, doctors, healthcare staff, any of you who have gone to university, like IMU, would have more detail than the average man on the street. So the law applies a different principle, a higher standard to doctors. And that is the Bolam principle test. So let's say you as a doctor, if you help someone with a wound, let's say the average person would be like, oh, okay, I watched this on TV. I should use whatever cloth I have to maybe stem the bleeding, right? This is the layman's perspective of what is reasonable. But maybe for a doctor, you have better knowledge than that. A reasonable doctor would do more. And that is the Bolam principle. The law would not ask, what would the average man do? But the law will ask, what would a responsible medical man do if that person was skilled in that job? So what this means is that the doctor must act in accordance with accepted practice. This also requires any of you as medical people, medical fraternity, to keep up to date in the field of medicine. What is accepted now may no longer be accepted 10, 20 years from now. What was accepted then may perhaps have changed. So if you only stick to what you learned in medical school and you say, no, this is the way I've done it, the way it's always been done, the way I was taught, but the rest of the world, or the rest of the reasonable world, has moved on and said that there's new practice now, you need to do this new practice, you could still be found negligent. Therefore, it's very important as doctors to stay in touch, keep in touch with, for example, your IMU alumni committee. So you keep having updated knowledge about what is going on, and you're more likely to be found not negligent. The second thing is that it should be found proper by a responsible body of medical men. So this is something that occurs every now and then, where when we look at cases like traditional medicine versus modern medicine. So I think it is it can be accepted that traditional medicine they do things differently from those who do modern medicine. And in foreign countries where there's very low awareness of traditional medicine, only modern medicine will prevail. However, in a country like Malaysia, where we have very two clear accepted bodies, you need to make sure that if you're doing traditional medicine, other people in the traditional medicine space would also agree with you. So this is why we tend to encourage healthcare staff that even if you later on join private practice or you stay in government practice, you do want to join associations or just be in an environment where you are up to date. So if you are doing more traditional kind of work, please make sure that your traditional work is accepted among other traditional bodies. So let's give you very specific cases because I think those are the most helpful examples to illustrate. We have this case with Chin Kiao versus the government of Malaysia. So in this case, he sued the Malaysian government because he had encounters with a doctor in public practice. So here, the doctor failed to inquire on the patient's medical history and did not ask whether the patient was allergic to drugs. So in this case, the patient had an adverse reaction and the doctor was found negligent and the government had to pay damages. In the second situation of Khao Nan Seng, we can see that there was failure to ensure proper monitoring of blood circulation after plaster of Paris had been applied. So sometimes something just as, even after the procedure, just being able to monitor the patient, those are things that can still be factored into for negligence. Your duty doesn't just end after your procedure is complete. You do have a duty to actively look out for patients that you have treated. And then in the third case, we have Chelaya Manikam versus Government of Malaysia. This is considered a failure to diagnose between appendicitis and pancreatitis, and they gave the wrong treatment. So failure to diagnose is something that can happen. After all, doctors are still human. However, if it is an unreasonable diagnosis, if most doctors who pass their medical school exams will be able to determine what's the difference between appendicitis and pancreatitis, then you can be held negligent. So what is a doctor's duty? It's actually broken up into three. That is number one, the duty to diagnose. Number two, the duty to treat. And the third one, which is often where doctors slip up and is often where the cases fall in Malaysia, is the duty to warn and the duty to disclose. I'll take them each in turn. So for the duty to diagnose, an error of diagnosis doesn't necessarily mean negligence. However, if a patient can show that the reason the doctor failed to diagnose properly is because the doctor didn't order the right test, or the doctor didn't carry out the examination, or the doctor didn't ask the right questions. So let's say you carry out the test, you ask all the right questions, you do A, B, C, and you still make the wrong conclusion. The fact that you have asked all these things at the beginning can help you in your case. You can tell the court that, look, this was a really innocent mistake. I looked and I analyzed the test and I reasonably thought that this is the conclusion. The court can forgive that and you will win your negligence case. Alternatively, if let's say the results show very clearly an outcome, but you still come to the wrong conclusion, that will mean that you may have a conclusion that no reasonable or competent doctor will conclude. That means you made a conclusion that was incompetent, and that can be something that amounts to a failure to diagnose. So like in the case earlier I mentioned, this doctor did not ask the patient whether there was any allergies, whether there's any pre-existing illnesses. In this second case here, Maynard versus West Midlands, the doctor must ask the patient relevant questions and listen to his account of the illness. We have seen sort of similar cases in Malaysia where the doctor did not ask the patient, the doctor did ask the patient, but the doctor didn't listen to the patient's answer. So it was sort of like a checklist thing where the doctor went, okay, do you have this? Do you feel this? Does this hurt? Rank your pain to me. And the patient shared, oh, this is really, really painful. This is the worst I've ever felt. My whole body's on fire. And the doctor just went, okay, sure. Difficult patient. So these are situations that can get doctors in trouble because it can show that the doctor wasn't really listening to the patient's account. All right. So, and then, and in the case of a doubtful diagnosis, it is responsible of a MO to ask a specialist for further consideration. So if you're not 100% certain, please encourage your patient to go and seek a second opinion. And that's one way you can protect yourself from negligence. You can say, look, this is my conclusion, but please, I advise you to ask someone else as well. And that can be helpful to you. All right. Okay, sorry, I just noticed a few questions, but I will go to that later on, Theodore. Okay. So next we have the duty to treat. In the duty to treat, this is after you've diagnosed them. So let's say you got the right diagnosis, what happens next? So there are very few cases, but specific cases where a doctor can look at the situation. In fact, not even a doctor, the common man can look at the situation and think, oh, this doctor made a big mistake. And this is what the law calls res ipsa loquitur, which is the thing speaks for itself, meaning it is so obvious that the court does no longer needs to make a conclusion. They no longer need to go and find all the separate elements. They can say you failed in your duty because you removed the wrong limb. You know, suppose cut off the left, you cut off the right. If you gave the wrong drug, although let's say it was already written out somewhere, the patient was already supposed to do this and you mistakenly gave the wrong one, sometimes that is so clear in itself, the court doesn't even ask any questions. You don't have an excuse. You can't say, oh, you know, the box was similar, it was blurry. This is clear opportunities for negligence. If you leave operating equipment, gauze, tissue paper, anything inside the patient's body, this is something the law will say, look, you made a mistake, full stop. There is no way you will get out of this without getting a negligence case. Your best bet here is to have a very, very good relationship with your patient to hopefully they don't sue you. All right, so that's about the duty to treat. So doctors do want to be careful, especially if you're surgeons. All right, and then in terms of the duty to warn, so this is where I mentioned that there were quite a number of cases in Malaysia. So when you share about risk or you warn about risk, it is different from the duty to treat because this is all very verbal. You know, this is, in fact, most of the time, doctors can leave this duty to the nurses. Some doctors feel that, oh, this is not my job. I don't need to talk to the patient. I just need to treat the patient. The ones who talk about the patient about risk, let front desk do that. Let customer service do it. Let the nurses do it. And this is a reminder that doctors have this duty to warn, and it's the doctor's duty. So what doctors need to do is that they need to disclose inherent risks in the treatment. And majority of the cases that fall within this scope are when doctors forget to tell people about material risk. And material means big risk. It can even be a small likelihood, but if the risk is big, for example, risk of death or risk of losing their fertility, these can be considered material enough, even if the risk is small, or risk of paralysis in the example written here. So let me share these cases for you. For Montgomery, in the case of Montgomery in 2015, the doctor failed to advise her of the risk posed to her baby during birth and the option of having cesarean section. In the end, the child was born with cerebral palsy. So the patient was an acute diabetic and she took insulin. So as the doctors may be aware, there's an increased risk of complications of birth in highly diabetic women, including an increased possibility of the baby's shoulders being stuck. So Montgomery in this case was not told of the risk and was not told of the option that she didn't need to have cesarean section. So in the only exception to the rule of when you don't need to tell the patient something is if you feel that the information you share is detrimental to the patient's health. So this can be used often in oncology departments where if they tell the patient the real risk or the real period that the doctor anticipates their life will end, it can actually have an adverse effect on the patient. In those cases, the court has said that no, the doctor did do the correct duty. However, as medical professionals, you want to make sure you don't overuse this exception. And you really need to be able to show that if you told the patient, it will cause them harm. Another situation is that the court looks at whether or not a patient in the similar position would think this is important. So like I mentioned earlier, there are some patients who can be unreasonable. You know, they expect you to tell them everything from top to toe. And sometimes that's not fair to the doctors or the healthcare staff. So the court tries to be even in this case. The court tries to say that, look, if someone else in their position wouldn't have minded, then that's okay. You know, if someone else who's reasonable in the same position wouldn't have asked for this very minor risk, like for example, if you had a scar and you didn't warn the patient that they could get keloids, you know, this may not be a big thing for someone who's going for heart surgery, right? Because they are more concerned about what happens inside. But let's say your one particular patient gets upset because aesthetically she was not pleased with the outcome of the scar for a major surgery like heart surgery, then I think this is something that the court will factor in and also say that the doctor was not being negligent. Another thing about Malaysia is that, and then this is a very controversial topic, is when it comes to fertility and consent. So for example, if we'll get into that later, but to see whether the risk is material to you, if a man could have his, if a man and woman decided that they no longer want to have children, they are already menopausal, or they've already informed the doctor that, oh, no, we do not want children. The doctor may not need to say that, okay, this surgery comes with a risk of infertility. And finally, we reach the final element of negligence, which is causation or consequential damages. Like I mentioned earlier, if you have no harm, the patient is completely fine, it's very unlikely they will be able to win on a case of negligence against you. In rare situations, for example, in the res ispa locutoire case, where it's so clear that the doctor has made a mistake, sometimes if the mistake is small, the court can award the plaintiff RM1 in damages. This has happened before, and in those cases, the harm is possibly to your reputation as a doctor, or sometimes you may no longer be allowed to practice. Your license may be suspended. So let's look at damages itself and causation. What causation means is that your breach of duty must result in the cause of the losses. So this will be just like the example I brought up earlier about turning off the lights. So let me give you a grocery store example here. The supervisor of a grocery store sees an employee drop grapes, all right? And then neither the supervisor nor the employee cleans up the grapes. And when you work in a grocery store, you have a duty to make sure that everyone who attends there, goes there, are safe. And an elderly customer steps and slips on the grapes and it breaks her hip. A broken hip is reasonably related to their breach of duty for not cleaning up the grapes, and therefore is considered proximate enough. And in those cases, the grocery store can be held liable. Damages is the final element. Because the plaintiff suffered injury or loss, monetary compensation tends to be the only form of relief for those damages. So it's very unlikely if you cause someone harm, you can return back the use of their limbs. So normally the court will ask you to pay out pocket to help them. This will include the list I shared earlier about medical care, lost wages, emotional turmoil, and more. For example, if you work in a sports equipment store and you have those heavy medicine balls, you know, the ones they do for weights, and you put it on a flimsy top shelf that you know it's not going to hold, but you're like, okay, never mind. One day, I just put it there for one day, I will buy new cupboards tomorrow. And when the shelf collapses and the balls start tumbling down and it hits the customer has a concussion, if the customer misses several weeks of work, you will need to pay them the wages for the weeks of work that they lost. Monetary compensation will compensate a lot more than just the injury itself. You will also cover them for the lost wages, sometimes loss of opportunity of being promoted. So this brings me to the next bit about consent. So we've heard now what constitutes negligence. You know, I think this is useful as a medical practitioner to know how careful you need to be. However, many medical practitioners will think, okay, never mind, I'll ask my patient to sign a form. If they sign a consent form, I should be protected, right? And this is an explanation of what's the best way to get consent. So the doctrine of informed consent means that whatever consent you get must be given with the full details. If your patient doesn't understand the language that the consent form is in, but they sign it anyway, that may mean that they do not have fully informed consent. So doctors have a duty to provide patients with sufficient information so the patient can say either yes or no. You know, the patient needs to make sure that the information they have is sufficient. If the doctor says, actually, there's no choice one, you only need to sign this paper, then you can proceed, and the patient doesn't have all the right information, that can be considered uninformed consent. So when it comes to written consent, sometimes doctors will think that, oh, okay, the patient verbally said yes, but there's no proof. Or the patient verbally said no, but he signed yes, right? Sometimes there are those situations of conflict. And the law doesn't say that written consent is the only way of consent. Written consent is just the evidence, it's just proof. You know, even if you don't have paperwork, you can still say that patient had consent. It just becomes a problem later on if you want them to go and testify for you. You want your nurses to go and testify in court and say, yeah, no, the patient said yes. So as much as possible, you will want anyone to have written consent. And if, like, for example, they come with their relatives, they come with a very persistent aunt or uncle who asks more questions than the patient themselves, you would want them to sign as well, just to protect yourself. So the federal court looked at this ruling, this Rogers versus Whittaker case, and they said that when it comes to consent, there are several factors that they think about. One is the likelihood and gravity of risk. Like mentioned earlier, if the risk is very small, if it doesn't seem likely, in those situations, it may be okay if you did not inform the patient. Another factor could be the desire of the patient for information. So I think in Malaysia, it's quite common as well to have patients who would say, doctor, don't tell me the outcome. I just trust you, I do. That can be consent, but you need to be able to show that you have tried to tell the patient more information. The patient had no desire to know. However, if you have a patient who is particularly persistent, if they text you many times, they ask you lots and lots of questions, these are considered patients who have large desire for information, and you will need to cater to that higher desire for information. In those cases, it is very likely that doctors probably need to get a witness just to make sure that the patient fully understands when they give consent, because these are the kind of patients that could later on say, no, the doctor didn't tell me this. The third thing is the physical and mental health of the patient. Sometimes consent from a very, very ill patient may not be held to be enough. Some of these patients can be considered mentally and physically weak. So when you are listing out a list of risks for them, they are not in the position to be able to absorb that. So in those situations, you do want to share more risks with other people. If there is a need for treatment and other alternatives, like the case earlier I mentioned about not having a cesarean section, you do need to share that with the patient. Medical practice at the time is considered a common thing that courts look at. If this is acceptable now, then maybe if they didn't follow everything, but let's say patients can consent by clicking yes on Google, that may be considered sufficient. And finally, the nature of the procedure. If it is routine, it is expected that doctors can share a little less information, but if it's complex, you do need to share more. So this is a case with Gurmeet Kaur versus Jaswant Singh and Tung Shin Hospital. Gurmeet Kaur versus Tung Shin Hospital. So this plaintiff was a 38-year-old mother of 4, and she sought treatment from the hospital and the doctor. So when it comes to legal cases, patients can sue both the hospital and the doctor, and they will put both names in the lawsuit. In this case, they sued them both. Normally, patients do this because when you try to sue the hospital, hospitals tend to, if the hospital loses, they have more money to give the patient. So in this case, they wanted to remove a uterine fibroid, and the patient consented. Yes, I want to go for the surgery. I want to remove the uterine fibroid. In the follow-up treatment, she discovered that hysterectomy was conducted and she cannot have more children. The patient was shocked, and the consultant said, oh, I'm so sorry about that. Sometimes even acknowledging through an apology can be something that is used against you. So you want to be aware of that as well. So what the court held was that although the patient signed the consent form, although she signed it, yes, I want to remove this uterine fibroid, she did not actually give her consent for the hysterectomy. She didn't understand the nature of the operation. She didn't know that she would no longer be able to bear children. So the fact that the patient was shocked was used by the court. It meant that she did not fully understand the nature of the surgery. So the patient also said that, look, the doctor did not tell me that there were other options. Hysterectomy should have been the last option being offered, and only if the patient no longer wanted to bear children. So in this case, we can sort of assume that the doctor assumed the patient already had 4 kids. Maybe the patient wouldn't want any more. But the patient said that, no, I still wanted the option. I still wanted to be able to have kids. And this was something that the courts held that the consultant was wrong. So in this case, because most consultants, once you join a hospital, you will sign an agreement with the hospital to say, I am an independent consultant. That means although you and the hospital are both sued together, the court can say only the doctor is wrong or only the hospital is wrong. In this case, the court said only the doctor is wrong, and the doctor had to pay $120,000 in damages for the loss of uterus, inability to conceive, injury, and pain. So if you look at my slides here, there's this point about the nurse who witnessed the signing of the form. So the doctor tried to ask his nurse, can you come and witness for me in court? Can you witness that the patient did sign the form, she understood everything? However, the nurse said, no, I don't want to come. I do not want to testify. And this is very common in Malaysia. Most of us are afraid or not willing to go to court to testify on behalf. And according to the Evidence Act, the courts can assume that if you don't have someone who will testify for you, you can assume that the nurse would support the patient. So let's say the doctor asks the nurse to come and the nurse says, no, I don't want. The court will assume that, okay, the nurse said she didn't want to come. This probably means that you didn't get proper consent. So this is something that it's an old act, it's an old law, 1950s, but we still practice it in Malaysia. So you want to be very careful about that the nurses who accompany you in the rooms will take your side, or at least you have a witness that can back you up. This is another case. Most of the cases here I'll be talking about cover fertility because it's a very interesting topic in Malaysia. So in this case, Norizan sued Dr. Arthur Samuel. So the patient and her husband requested to terminate a pregnancy and insert a contraceptive device in one procedure. So the defendant, which is the doctor, agreed to carry out the procedure, but did not tell them the risk of performing two procedures at the same time. During the procedure, the doctor perforated her uterus, and this is something that can happen, right? I mean, this is just a normal situation. It's a complication of any kind of procedure. But the husband and the patient said that if I had known that there was this risk, I wouldn't have carried this out. If they had known, they would have opted for a safer method rather than going for both in a single procedure. So the failure to inform the risk, it means that the patient had no choice. The patient was denied other alternatives. Sometimes when I speak with doctors, they will tell me, the patient could have Googled, they already Googled before this, they already know their options, but when they came to see me, they already know what they wanted. That doesn't take away the doctor's duty. As medical professionals, you have an enhanced and higher knowledge. Even if the patient has Googled the information before, you are expected to repeat that to the patient. And that is the information that will count when it comes to looking for consent. Okay, here we have another case. If I'm getting too depressing or I'm sharing too much that's making you uncomfortable, please feel free to comment and then I can move on away from the cases as well. So this is the case of Abdul Razak, and this patient was deceased. It's a 71-year-old with abdominal pain, vomiting, and had intestinal obstruction. The patient was admitted to Temerloh Hospital, later transferred to HKL, and it was under the care of this doctor. So the deceased husband knew the first defendant personally. So the deceased husband was friends with the doctor. The doctor was away attending a conference, and in that time when he was away, he asked his surgical trainee, can you please insert a Rowell's tube to pump out stomach fluid? And the patient said, no, it's uncomfortable. I don't want to have this Rowell tube insertion. So that was recorded. Then the doctor called the deceased husband and said that, hey, your wife needs immediate surgery. And the husband said, okay, can. But there was no risk mentioned by the doctor about the importance of inserting the Rowell's tube before the induction of anesthesia. So we can see here that the patient was allowed to say, no, I don't want the Rowell's tube, but they need to be told the risk of their refusal. After the induction, the deceased or the patient regurgitated a large amount of stomach fluid, which entered her lungs, causing respiratory failure and death the next day. So the husband sued, and in that case, the husband won. So although the consent form did not require the consent of the patient, did not require the consent of the husband needed to be informed of the risk because the husband was the person making decisions. So sometimes in this case, the doctor can say, oh no, look, the patient themselves refused the Rowell's tube. But it doesn't matter that the patient then alone refused. You may need to ask the husband as well, because the husband was clearly the person making decisions there. So this is almost a unique situation in Malaysia. I think in most Western countries, the patient's consent alone is quite important, and important enough unless there is a mental or physical disability. However, in Malaysia, if the main decision maker or the primary decision maker is not the patient, you need their consent in order for the consent to be valid. This can apply also for elderly parents whose children are making decisions for them. So those are, even if the elderly parent says, no, I don't want this treatment, you may need to ask the consent of the children as well. All right, and then in this case, it was very clear that the deceased husband was the one making most of the decisions, and therefore his decision was needed when it came to the refusal of the Rowell's tube. All right, and now we want to look at consent in general. So in Malaysia, spousal consent is necessary in these two situations. Number one, where the issue concerns the reproductive rights of both parties. And that can even be when it comes to aborting a child. If you are married, you may, as a doctor, you may need to get the consent of the husband as well. And in the second case, the spouse was dependent on the other to make the decision. And in this case, it was clear that the husband had to make decisions for the wife. So this is something that you also need consent of the husband for. All right, and when it comes to all of these things, as I mentioned earlier about written consent, you do want to keep good documentation. So proper documentation of case notes, lab results, x-rays, consent forms, PDPA, all of these must be kept. And in most circumstances, this will be done by the hospital you work for, the clinic you work with, but doctors themselves have a responsibility to make sure their part of the consent form is properly filled in. It should not be done outside the doctor's view. So we've also seen cases where the doctor will check, sign later on, or pre-sign, and then the patient signs hours later or a day before. These are irregularities that can cause issues in court. So you do want to make sure that the doctor is signing on the same day, or ideally in the presence of the patient as well. So in the event that the hospital is asked to release documentation, the hospital has a choice. The hospital can say, oh, no, we cannot release this patient information. We don't want to give you the doctor's notes. Or sometimes doctors write not so good things in the notes. We've definitely seen notes where the doctor writes a really fat patient, very unpleasant, details about the family, like rude family members. These are things that later on become issues in court because it can imply that there's some prejudice. So please be careful with the notes that you write. And then if the hospital refuses to give the notes out, the court can once again assume that it means the notes hold something bad. So in most cases, hospitals will generally agree to release this information. In addition to that, the guidelines of the Malaysian Medical Council also states that the patient may be entitled to access medical records that relate to them. So anything you write about a patient, the patient may have rights to ask for it. If you refuse, this may be allowed. However, when it comes to court, the court can compel you to disclose. So at the end of the day, if the patient decides to sue, you will have no place to hide your documentation. So you do want to make sure that you're making good notes at all times. So when we look at documentation in general, this is the rule, right? Written evidence carries more weight than oral evidence. And if you have a good record, you have a good defense. If your record is bad, you have a bad defense. But if you have no record, you have no defense. So in order to encourage transparency, reporting, open disclosure, we do encourage all medical professionals to keep good records. All right, but here at the Q&A, this is the end of my presentation. So I've shared a little bit about how negligence works in Malaysia. Hopefully this has been helpful, but here I can take some questions. Richard, if you would like to help me facilitate this.
Oh, thank you, Tiffany, for the talk. It was so much information that we didn't know.
Sorry, I may have bombarded you guys a bit.
Yeah, that's a lot of information. I've learned a lot personally. So let's start with the questions first. Theodore asked a question. Does LOCUM exclusively for those in West Malaysia? She's currently not practicing in a hospital background, and can she apply for LOCUM?
Okay, sorry, I probably need some background whether Theodore is a doctor or a nurse, but we also
unmute yourself.
Yeah.
Theodore.
Hi, Tiffany. Hi, Dr. Richard. So I'm actually a nurse background.
Mm-hmm.
Yeah.
Do you have an APC or are you?
Yes, I'm.
Okay.
My APC is still valid. I keep it valid for the last 10 years, the last 11 years actually. However, I'm not currently practicing in a hospital, but I do still engage in clinical when in my workspace.
Yep.
Although it's not a clinical setting, however, I do in terms of consulting my medical staffing out in the offshore rigs.
Understand. Okay, so for the law in Malaysia as a nurse, as long as you have a valid APC, you are able to carry out locum jobs even in a hospital setting. We also have jobs and we have opportunities for people to register in East Malaysia, but we will admit that our jobs are very minimal. So if anyone is in East Malaysia, please recommend hospitals and clinics to us, ask them to use our app, and then hopefully there'll be more jobs for you guys. But yes, Theodore, feel free to register on the app. And if let's say we have home nursing work as well, then you also can consider those too. Yep.
Thank you, Gabriel. And Doctor, I'll ask a question. Does capacity work differently here compared to the West? How often does a psychiatric assessment is required for capacity to make medical decisions here in Malaysia?
Okay, it's a bit difficult to compare with the West. I can tell you from my knowledge of England. So according to English law, capacity means a patient's capacity to consent. So according to law in general, if you do not have the mental capacity, you do not have the age capacity, your consent is considered invalid. In Malaysia, we do look at mental capacity and we do look at age capacity, but it is not often that a psychiatric assessment is required for capacity. Normally, you would have to be very, very heavily incapacitated in order for them to say you do not have capacity to consent. And most of the time, if let's say you make a decision in January, but the court case is in June, you want to say that I didn't have capacity in January. The court can sometimes say, oh, too bad, you only did your psychiatric assessment in June. It does not mean that you had no capacity in January. So those are some of the complications that can happen in Malaysian cases. So most of the time, the law will just assume you're an adult. Let's say you've not been admitted to anywhere, you've not been diagnosed with any capacity issue. The assumption is that you are an adult capable of consent. I hope that answers the question. But yeah, Songwai, please feel free to introduce more psychiatric assessments.
Thank you.
Okay, is there more questions coming up? Okay, meanwhile, let me summarize. We understand there's a lot of responsibility housed in healthcare workers. It doesn't matter you're doctors, you're a nurse, you're a psychiatrist, you're a dietitian. As long as you're working with patients' life, there's a lot of responsibility hold. And I understand that law is not against us. It's everywhere. It just depends how you're going to use it, how you're going to utilize it to protect yourself. And documentation, as just now Tiffany mentioned, is very important. I personally work in hospital setting. That's what in government hospitals see. Normally, the houseman will be one doing the documentation. So, as junior doctors here, as MOs here, please do cross-check and make sure the housemen are documenting the right things. And just because you mentioned every teacher, every sentence means something to you. Yeah, and not forgetting, keep our self-competence and do inform patients things that you can foresee, and please read up and keep ourselves up to date. Yeah, and yes, sure though. Yeah, me yourself.
Hi, I was just mentioning when Tiffany mentioned about with the right and proper assessment has been done by STU, there is sue has been done towards a person. However, again, although with the correct assessment is done, there is a gray line between the professional diagnosis and differential diagnosis, which can lead to a different final diagnosis.
Yeah. I think in Malaysia, honestly, the medical expert scene is quite small. A lot of the doctors we speak to have been invited to become the medical expert to also share their views, especially when it comes to situations like this. So one day when you guys are also invited to go to court to be a medical expert, they will also offer to pay you, of course, for your time and your trouble. But in those situations, I think that if you are up to date, on what, and a reasonable man, even if your expert witness doesn't agree with you, if a reasonable doctor would, then you should still be protected, so to speak.
Yeah, just to add on, Chadro, I personally think provisional diagnosis and differential diagnosis, there's a reason why you put it as a differential diagnosis. So you have to do something to rule out why is it the differential diagnosis. For example, if patient coming with an abdominal pain, the most red flag we think of pancreatitis, and of course you can rule out appendicitis, but how do you rule out? Because of location of pain, the test you have done, this is why you have to justify yourself.
Yeah. And you want to make sure that the patient knows that as well. Okay, there's another question.
Yeah. Okay, now I'll read for Yishan. Is it eligible writing a medical negligence? Does it carry heavy consequences?
Okay, my question about illegible writing really depends on the person writing it. If you write something and you yourself cannot read it later on, it can have a problem because it will be as though there's no record. But let's say you write, you understand, no one else understands. As long as you can prove that this is the way you write, you can replicate the same style of writing, you can show that this is what you meant to say, then it doesn't cause a problem. It's like typing with typos, basically. If someone can still sort of understand what you're saying, the court will be like, okay, fine, this person just has ugly handwriting, or this person is careless. Yeah.
Yeah, this also seen in hospitals, whereas when doctors document, they put in short forms, which we try to avoid. Yeah.
Yeah, but shorthand is okay if other doctors can understand it. That has come up a few times. But as long as the doctor understands it, it's not a problem.
Guan Ki. Would you like to unmute yourself, Guan Ki?
Yeah, sorry. So I'm actually one of the hospital administrators, and we do receive a lot of formal complaints from patients saying that some doctors, they didn't inform they did something wrong. They did something wrong and all those things. But when we did the investigations, the documentations actually states otherwise. But in that case, how can we prove or ensure to the court, if let's say that they do sue the hospital or the consultants, how do we ensure that or prove that the proper documentation and procedure has been done?
Yeah. Okay, so I think we mentioned earlier about how that although the patient gave written consent, the court had held that this consent was not valid. So this is something that's very worrying for hospitals, because as you look at the documents, you would think, okay, everything is in order. But then later the patient tells a different story. So the way we normally try to cover up for that is that if you have a column at the end of your thing where it's written by the patient, that can help, where it's not just a checkbox. So those are some forms that they introduce, I think, in certain places where the patient writes in their own summary or like a note section about what they understood about the procedure. So this is very clear evidence that the patient did understand and they're changing their story later on. Another thing, of course, is we recommend that consultants don't see patients alone. This is also now, I think, one of the hospitals I work with is one of the ruling. Like if you are a female patient, you are not seeing the consultant alone if it's male. So it should always have a female nurse in the room, especially sometimes patients they don't know what else to complain about. They may try to go with the assault route, even if it's not true. So as much as possible, we want to believe the victim, but in many cases, we also know that patients can say things. So what we recommend is that you always have a witness, and this witness is someone who will be willing to testify on behalf of the doctor. And the second thing is, if it's possible for you to get evidence from the patient themselves, either written or not just a checkbox, then that will help. Yeah. Okay, I also have another thing I would like to share with the doctors. So I can take one more question and then I'll go on really quick to share this opportunity, or how you can use technology to prevent cases of negligence as well. Is there another question?
Any question coming up? Maybe Tiffany can share the technology first.
Sure. So one of the products that we do in iHeal is that we have a subsidiary called Our Checkup. So I'm not sure whether any of you have heard of Our Checkup, but it's a digital health specialist launched by one of our subsidiaries. And what it does is that as MOs, doctors have patients with a lot of information nowadays. You know, patients wear smartwatches, they take their blood pressure, they go on the body composition scale, and all this information is occasionally not used by doctors. So like for myself, for example, I wear a watch, you know, and I track my steps daily, they track my sleep. But when I go see a doctor, it doesn't occur to me to show my doctor my smartwatch details. You know, I will tell my doctor, oh, I haven't been sleeping well. The doctor will ask me, is it recent? How's your blood pressure? They'll check it on the day itself. Let's say it's a bit high. I will say, oh, doctor, I have to climb a long flight of stairs to see you. You know, I mean, as a patient, I can tell you that sometimes I do not want to get like caught out by my doctor. So 2 or 3 days before, I will take very, very good care of my health. But as doctors, you also know that when you see a patient in the clinic, you only see them for that pocket of time. And there is so much data that, you know, has been collected by the patients themselves that can actually be used to help you diagnose them better and recommend better treatment for them. Like for example, their heart rate. So what this app does is that all of the information collected from Internet of Things, they pull out 17 risk factors that contribute to heart disease. As you are aware, heart disease is still the #1 killer in Malaysia and globally. And this is something that the number has come down a lot, heart disease related to death, because it's preventable. You know, death from heart disease is definitely preventable. And the monitoring and management of risk factors are actually what can help you prevent heart disease. And all these factors can be measured by the things that we use almost daily, from the smartwatch to a blood pressure monitor to your weighing scale. So this app promises, or it recruits doctors to get their subscribers or their patients on board. What you will be able to do with this app is that once your patient subscribes to this program, they will be given the Fitbit smartwatch, they will be given the body composition scale, they'll be given a blood pressure monitor, and all of this will be synced to an app by Bluetooth. So it's no more having to ask your patient, go and write down your blood pressure every day for a week or a month. This is automatically synced to cloud, and you as a doctor, you can have as many subscribers as you want. You can recruit subscribers onto the platform. And what we just calculated and estimated, right? Even with just one subscriber a day, you can earn an additional 2,250 a month, and that is 27,000 a year. But imagine if you see 4 subscribers a day. Each subscriber comes in, you already have the information on cloud, you've already downloaded the phone, the app, all this data is already synced and stored in a report. You don't even need to analyze it anymore because the app does it for you. You can see that, you can help your patients. And if you see 4 a day, that's what, maybe 20 minutes per patient. You could see less 1 hour plus, and you can earn an additional 108,000 a year. So this is what our checkup can do for doctors. What we sell to patients is this. The sale of the package is 1,488 for 1 year subscription. The Fitbit, the blood pressure monitor, and the weighing scale, it's all included for free. This is original Fitbit, and they keep it, is theirs. There's no more after 1 year you have to return it. It's 100% theirs, and it's 1,488. You as a doctor will see them 4 times a year. As a medical officer, later on when you guys graduate, when you finish your housemanship as well as a medical officer, I think one of the concerns that they have is that how do you retain patients? A lot of patients are doing self-management of care. However, the integration of doctor care and self-management of care, I think, is the future, because patients can Google all they want. We can look up our own data, but we're never really going to be able to replace a doctor. And this is where, instead of recommending doctors, instead of recommending AI technology, we think that partnering the Internet of Things with the doctor is the way forward. So I'm inviting any of the doctors here, if you would like to be interested to be part of this digital change, please feel free to register on this app. You can download our checkup. It's also available on the App Store and Google Play. My colleague will send a link in the group chat as well, where you can download the app. So that means that individuals that only pay 1,488, they can pay by subscription. So they pay a fee per month, and that's only 100 something per month. So how it works is that you as a doctor, you will see the patient. There will be a portal on the app that it will sync to you, and you will slot appointments 4 times a year. Every time the patient sees you, you'll be paid 75 ringgit per visit. And these patients or subscribers, we will try to find them. You can also recruit your own patients that already see you. This can apply even if you have your own patients in public practice or private practice. It doesn't matter, because it's an application that works like outside whatever system you are doing. Down the line, we may open this for telemedicine as well, so it'll be easier for you to see the patients. And this is an example of the report. So all the information will be already synced in this sort of thing, and you have a conclusion at the right-hand side. You see this green thing? If the patient has red flags, it'll be red. So it's much easier for the doctor to gather the patient information. And the real difference is that this is daily info. You're not just getting medical record of every quarter, but you're getting daily medical records, averages, charts. So this, we believe, can help doctors be better doctors to these patients, use data better. The benefits is that for doctors, you will get involved in digitalization. You can use technology to manage chronic diseases. You can retain existing patients. They can see you 4 times a year instead of every time they want an MC. You also get to acquire new patients. It's a new revenue stream. And also we believe that this can help you make better clinical decisions. For subscribers, you increase the ownership of the health and health data. For me personally, I've loved being on this program because when a doctor when I Google, it tells me I need to be a certain weight. But that's not achievable for me in 1 month or 2 months. But the doctor can set specific targets, which really help me. In addition, you can predict your own sickness. You can work with a customized treatment plan by the doctor. There's more engagement. You really have a different relationship with your doctor, and you have instant access to health data. At any one point, the doctor or patient can view their data on the cloud. And it's very easy to be a panel doctor. Just download the app. We are open to any doctor at the moment. So if you're interested, you either can send a message to the Our Checkup Facebook team, or you can just download the app straight away and sign up. And the management cycle, like I mentioned earlier, is really straightforward. The patient themselves downloads all the information. They use the devices. They get all the data collection. You as a doctor, the first visit, you set health targets for them, either to maintain, either to improve. And when the patient continuously records their data, you can then track whether or not they're improving using the 10-year cardiovascular risk score. And yeah, that's the end of our checkup. Let me see whether there are questions on this. Is there anything you would like to know?
And yeah, those participants who because we're looking because we're recording this session and we've uploaded in YouTube, so actually feel free to watch back and going through all the slides again. Yeah. And please fill up this feedback form. You can just scan this QR code and you'll be very useful to help us in organizing the next career talk.
Okay, I think that is all. So just thank you so much to IMU for giving me the opportunity to share. I'm happy to continue any questions or conversations. If anyone still has questions, you can reach out to me on LinkedIn or even on Instagram, and I'm happy to speak to anyone. Okay.
If there's no question, I guess that's all for today. Thank you, Tiffany, for joining us today. Giving such valuable thoughts.
Thank you.
Thank you, guys.
Thank you.